Yes. What is the urgency?
So if I file a GAT application, that's the application error.
Hmm.
Despite of the pendency of the lead application, the private respondent is continuing with legal activity error.
Civil suit is pending?
No civil suit. No
No
I
civil.
think we put some put challenging the order passed by the deputy commissioner. You are supposed to the order of the deputy commissioner. It has been having the status in deputy commissioner order that certain direction was given to the personal concern. After that, till the personal concern is taken the completed that direction, stay was granted by the DC. In spite of that, the private was deleting that. Yeah.
Tomorrow? To be mentioned. Yes. Call the list.
Your Lordship, this is the matter wherein my client approached the Calcutta for issuance of this.
Mentioning? Is a mentioning?
Yes, Your Lordship. Yes, Lord. For issuance of sketch map and premium, Your Lordship. Till that the matter is pending before the Calcutta, Your Lordship. The previous day, the authorities concerned take time for filing AO, Your Lordship. Then it's pending, Your Lordship.
Affidavit is filed, not?
No, no, Your Lordship.
November 2024, there is a direction for filing affidavit, not yet filed. Is tomorrow
One more.
to be mentioned?
Mention. Back to the matter.
Give. Whatever the mention, give. To be mentioned.
This saying is appealing for the bid petition, practice out of this mirror, paying for
Why you mentioned?
this part of my hearing.
Who is for the other side? Affidavit filed.
Is filed.
It is completed.
Yes.
Affidavit आया? Affidavit in reply. Where is the affidavit in reply? You not file. You will not file.
No.
Hearing.
Yes.
The matter is listed as to be mentioned on the pair made by the counsel for the petitioner. Counsel for the petition submitted. The dependent respondents have already filed affidavit in opposition. The petitioner will not file any affidavit in reply and prays for fixing the matter for hearing. In view of the above, let the matter appear on 8 July under the heading hearing. Next.
This might also my savings are being for state certain direction. Then Tehsildar Pragati has been directed to allot some land. The same.
Allotment of land.
Yes, sir.
Then.
The same has been kept in abeyance by the authorities for a time, and again this all time. And the matter is out of this organization is private to.
Who is for the authority? Huh?
Please, Kavita Raj is appearing.
So no, affidavit is ready. You will not file affidavit in reply.
No.
So why the matter is fixed for hearing? Order dated 19 February 2025.
Means the order 5 October order.
5th October.
October 2024 order.
Yes. That's one number for director submit a detailed report before this court within the report is filed.
No,
It's the report is here. You have not received the report.
no.
Have you not served the madam? Report is not served. Okay, sir, the report I am fixing on Friday. So and so offering for the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petition submitted respondents have not filed the report in terms of the order passed by this court dated 5th October 2024. It is found that a report is on record. The counsel for the respondent directed to serve the copy of the report in learned counsel for the petitioner by tomorrow. List the matter on date on 4th July under the heading hearing. Next.
Nothing of 1.1. It's like all of my singing for the petition. Already coordinate been passed and not directing them to file their affidavit in opposition. Imagine that.
My opinion is better that the parent was responsible for it. Already filed affidavit of opposition to your lordship before the registry 26th March.
Affidavit
Opposition.
filed and not sought the copy. You will file reply.
Yes, ma'am. Let it come on Monday.
The matter is discussed to be mentioned on the prayer made by the counsel for the petitioner. The respondents have filed affidavit in opposition after serving the copy to the counsel for the petitioner. Counsel for the petitioner prays for time to file reply. Let affidavit in reply be filed by Monday. Please the matter on 9th July. Next. Under the heading hearing. Next.
Four, of 125. The first one, my skills, we have filed the affidavit in opposition today. We have filed, my lord.
Already filed.
They have not received copies. I'm giving copy, my lord. This is just no.
So you file reply.
Yes, ma'am. On Monday.
Same order. Same order. Come on 9th.
I'm here.
Under the heading hearing. Next.
Lord, I am appearing for
Yes.
I am for the petitioner. This is an application under the 480.
What is the offense?
D2C.
What is the quantity?
Requirement.
That is not there. What is the quantity?
The commercial quantity, but non-compliance of the grounds of arrest, which is mandatory as per Article 22(1) of the Constitution of India. Very recent judgment.
Yes.
Because the startup.
Which PS?
Yes.
When?
Mayavandar.
Friday?
Friday, not because. It's on Monday or Tuesday.
As per the prayer made by the public prosecutor, case is adjourned. Let the matter appear on 8th of July. The state is directed to produce the case diary on the date fixed.
HCR can also be part of the.
Case diary is there. Next.
Appearing for the petitioner.
Yes.
Lordship, the order passed by the learned district judge, 4/6/2025. This judicial case is being challenged here. The Lordship, this instant case relates to an application filed under Guardians and Wards Act, an
Correct.
application under Section 7. When that particular application was filed, as per Section 10 of the Guardians and Wards Act, following that, complying with Section 11, the notice was served by publishing in the daily newspaper. After the service of notice, the learned district judge acknowledged the service of notice by a particular order. Following that, the three witnesses were brought in for evidence, that is the petitioner hearing, mother of the minor, and one more official witness. After that, the case was fixed for argument. When the argument was completed, the learned district judge had passed an order stating that this particular case, in this particular case, which is filed under Guardians and Wards Act, there will be application of Hindu succession. And as such, the person who is class 1 legal hire, that person also has to be brought into this particular case and made as a part. So, challenging this order, I have approached this honorable. Now, your lordship,
The application under section 7 is filed for what purpose? Property and person?
your lordship.
For the purpose of property and person or only the property?
Only the property.
Only the
This is for the
property.
purpose of receiving the benefit of family pension,
Okay.
which was because of the expiry of the father of the minor. The father of the minor used to work in the Indian Army. After his expiry, the family pension benefit, which was to be received by the minor, the authorities have denied the benefit of family pension, stating that there is no legal heir appointed by the court, and therefore only after one guardian is appointed by the court, the benefit will be released to the minor. And as such, the maternal grandfather of the minor approached the London district judge and filed an application for appointment of guardian.
Correct.
Now, your lordship, the question here is, first of all, whether the issuance of notice has been complied or not. Your lordship, the issuance of notice is discussed under section 11 of the Guardians and Wards Act.
No, that is secondary. You have made an application for appointment of guardian with respect of the pensionary benefit, family pension and benefit, correct? Of the father of the minor.
Correct.
And mother is the accused in the allegation against the mother that she has committed murder of her husband, who is the father of the minor.
Correct.
Correct. Now you want that this petitioner should be appointed as a guardian for the purpose of pensionary benefit, so that the minor can get the benefit of the pension. This is okay. So this is the maternal mother, maternal grandmother,
Maternal grandfather.
grandfather, correct, maternal grandfather, whether paternal grandfather is there or not?
Lordship, the paternal grandfather and paternal grandmother are
Not alive.
not alive.
Okay.
Your lordship,
So, whether you have mentioned in the application?
Your lordship, it is not mentioned in the application, but that in the application there is schedule of near relations. Schedule of near relations which have been incorporated in the application which has been filed. In that, the near relations are mother, maternal grandmother, paternal uncle, and other three people are paternal uncle and aunt. So the paternal grandfather and paternal grandmother are not alive. Now, your lordship, this is a case which relates to
When they died, paternal grandfather, grandmother, where is your averment in the application? They are not alive. You might have been given the details of, but where is the averment that the paternal grandmother and grandfather are died prior to the filing of this application, or when they are died? Because as per you leave aside the Hindu Succession Act, if you go by the CCA rule and pension rules, so it has to go by the minor and mother of the deceased. Mother of the deceased as per the pension rules. She will not get the pension in the minor, but the other benefit will get the benefits.
Your lordship, with regard to that, your lordship, I would rely on section 8 of the Guardians and Wards Act.
Give the Guardians and Wards Act. Guardians and Wards Act. Guardians and Wards Act. अल्फाबेटिकल नहीं है? Section 8.
Your lordship, section.
Yes.
An order shall not be made under the last foregoing section except on the application of the person desirous of being or claiming to be the guardian of minor or any relative or friend of the minor. Your lordship, there is no specific bar as to who can apply.
Correct. There is no bar.
Your lordship.
But when a person XYZ, if he's not a relative but is a next friend, whatever it may be, he can apply it. But in the person who is entitled to be heard, the notice is to be served.
Your lordship.
And if you're telling the maternal grandfather and maternal grandfather, they are the legal heirs of the deceased. Correct. And this is a pensionary benefit.
Your lordship.
Pensionary benefits. So if the pensionary benefit, if the maternal grandfather and mother has been appointed as a guardian for receive the retirement benefit, and the mother is having the allegation of murder of the father, so the paternal grandfather's right will be affected.
With regard to that, I would like to point out that at present, the custody of that particular minor child is with the maternal grandfather. Had it been otherwise, then the person with whom the custody of the minor would have been, that person would have been made a party. And secondly, the remaining legal heirs who are there, they have intimated to the in the daily newspaper, and there is no person who has contested in this particular. And therefore, this case has proceeded ex parte.
Correct. I am telling that I am not denying that. With regard to the paternal, you have not mentioned with regard to that they are the deceased, they died. Where is the averments in the application?
Lordship, para 10, the
Hmm.
other near relations of the, there is no specific.
That is the
they have
problem. That is
expired,
the-
but the
yes.
remaining near relations who
And
are there.
correct. That I have gone through that. Paragraph 10 also in the schedule also you have given the name. Schedule also you have given the name, schedule 2. Schedule 2. But with regard to the, where is the averment, the mother, maternal grandfather and mother?
Lordship, I would like to see duty by the subsidiary here.
Supplementary will not serve the purpose here. Supplementary will not serve the purpose here. You have to take up, amend the application which you have filed before the district judge.
Your Lordship, in that case, Your Lordship, I would seek the liberty given to file appropriate amendment, and if that appropriate amendment is being filed and considered, in that case, there is no requirement for again service upon those persons who have already expired.
Correct. If you have a document, the maternal grandfather, grandmother expired. That's why the notice was not served. So if it expired, naturally the order bath which order the impugn, wherein the learned district judge has passed an order to make the mother as a party to the suit. So that does not arise.
Lordship. But with regard to, as per the instructions from my client, both these people have expired long ago, and there is no certain document as now
We
available.
have to prove. We have to prove. Census and suffering for the petitioner. No, the petitioner has filed the present divisional application, being agreed and dissatisfied with the order passed by the learned district judge, dated 4th June 2025, in Miss Judicial Case number 24 of 2024, wherein the learned district judge has directed the petitioner to take necessary steps to add mother of the deceased Vishnu Mandal to be a party in this case if she alive, and in case of death, other persons who will be entitled to be inherited through the mother of the deceased be added as party in this case. Full stop. Counsel for the Mr. Adarsh Enangal and advocate appearing for the petitioner submit that the petitioner in the application filed under section 7 of the Guardians and Wards Act, read with section 29 of the said act, in paragraph 10 has categorically mentioned with regard to the near relatives of the minor. And as such, and after this, and the petitioner has already published the notice of the instant case. And after the publication of the notice in the Daily Telegram, none has appeared in the said case for raising any objection. He submits that as the publication has been made in terms of section 11, or rule 11,
Section 11, read with rule 296.
section 11, and read with rule 296 of the Guardians and Wards Act 1890, and as such, the order, and as such, there is no necessity for adding the mother or any other necessary party as directed by the London District Judge by an order dated 4th of June 2025. Had the London Counsel for the petitioner. This court find that in paragraph 10 of the application, the petitioner has given the details of the near relatives of the minor. But the petitioner has not disclosed with regard to the details of the grandfather and grandmother of the minor. When this court inquired from the petitioner why they have not been made, the counsel for the petitioner informed this court both maternal grandfather and maternal grandmother have passed away, and as said, they have not disclosed their name in the relatives of the minor. This court perused the application filed by the petitioner under Section 7 of the Guardians and Wards Act, read with Section 29 of the said Act, but this court did not find any averment in the application wherein the petitioner has mentioned that the grandfather and grandmother have passed away. There is no document is disclosed to say that the grandfather and grandmother of the minor has passed away. Full stop. Counsel for the during the hearing, learned counsel appearing for the petitioner prays for leave for taking appropriate steps before the learned district judge in his judicial case number 24 of 2024 by way of amendment in the application filed under Section 7 of the Guardians and Wards Act, that is Section 29 of Guardians and Wards Act 1890. Consider the submission made by the counsel for the petitioner. This court is given liberty to the petitioner for taking appropriate steps for amendment in the application under Section 7 of the Guardians and Wards Act before the London District Judge within a period of 2 weeks from date. Serial number so and so is disposed of.
After the passing away, we mentioned paternal grandparent, which is their paternal.
Paternal cousin, na?
Right.
Next.
Observe the copy of the official respondents as well as.
Yes.
Private respondents.
Yes.
And finally, the application challenging the order of the Sarah. Um, 31.
Page 31. Yes.
So, in the discussion of this order, your option, asking the revenue staff, enter into my land, your option, land with my father's land, my father is at 5 years, and cause damage to the land. You kindly appreciate, I'm just essentially property part of the, if writ petition has been filed by the private respondent behind my back. Now, this petition was disposed of the administrative university, whereas the Honorable High Court of Calcutta passed an order dated 24th March 25 in the matter WPA 74/5 as the petitioner device is only with regard to demarcation. The present writ petition can be disposed of permitting the writ petitioner to apply for before the concerned Tahsildar for demarcation of public property.
Correct.
If any application is made by the petitioner
Correct.
within a period of 4 weeks from date,
Yes.
concerned Tahsildar shall, after consulting the record, and if it is found that the property is recorded in the name of the petitioner, shall demarcate the petitioner's portion in accordance with law after notifying and giving opportunity of hearing to all interested parties, including the petitioner. Now, there are two things on document. The petitioner has to apply first for demarcation. Thereafter, the Tahsildar has to give opportunity to all the concerned parties that have to party. Now, this interim order has been passed on 12th April 2025. I specifically avoid in my writ petition that this order, the compliance of the writ petition was passed on 12th 2025, was served on 11th 2025 at 3:30 p.m. So, Your Lordship, in accordance with this notice, Your Lordship, the Tahsildar has entered into my land, Your Lordship, without any demarcation, anything, Your Lordship.
Okay. They have issued the notice.
But-
Correct. The notice is issued to you, no?
No, yes,
No.
one of the, I have received this notice.
Correct.
As per this notice,
Ah.
this is an order, Your Lordship. Though it is reflecting as a notice, but the Tahsildar concerned acted as an order and he entered into my land, Your Lordship. But as per the Honorable High Court, there are two things, Your Lordship. The writ petition has to first file an application. This order has been passed on 24th of March.
Correct.
Whether that application has been filed for demarcation has been filed by the writ petitioner or not, I am not aware.
The private respondents are there.
Yes, Your Lordship.
Have you served?
Sir, Your Lordship was to speak. No report has been come here.
Let the notice be served.
So,
They have to be heard.
I'm just saying for interim order, Lordship,
For what interim order?
Lordship, no action be taken by any of the authorities, status quo, Your Lordship.
For what?
To interfere my land, Your Lordship.
See, the demarcation notice was
It is,
on 12/4/2025. What has happened on that day?
they just entered my land, Your
Ah,
Lordship.
no demarcation was conducted.
No, notice has given for demarcation as per this on.
No, this notice, page 31.
Not demarcation notice, this acted as an order and they entered a Lordship and.
No, now therefore the parties involved are hereby required to attend the field on 12/4 at 10:30 for further process of the matter. Correct.
I insisted to enter my land, Your Lordship. I have given notice, immediately I have served a notice to Deputy Commissioner about the entire fact, Your Lordship, to my legal notice, Your Lordship, on 24/25. Stating that the action of the revenue authorities is totally illegal, they have without any in protecting compliance of the High Court order, they have just disrespectfully and disregard of the order, High Court order, they have
Okay.
conducted the entire thing, Your Lordship, and entered into.
Okay, I will clarify only in terms of the in terms of the order passed by this court in so and so, if any application is made, and in terms of the notice, only the Tehsildar is empowered to demarcate the land and not to disturb the possession if you are in occupation of the land.
As per paragraph 2. As per the direction of this honorable court, petitioner is presented outright for demarcation.
No,
Application has been
a
made.
revenue case has to be initiated on the application.
Okay,
No, nothing has.
okay, you see where you have brought the RC case. You bring the RC case, I will see to that.
Yes, sir.
Whether what application they have made. In the meantime, you also track the track report. You said track report. Come when? Friday? So the petitioner has filed the present writ application being agreed with the notice issued by the Tehsildar for demarcation of the land in question. Full stop. Mr. V.D. Sivabalan, an advocate appearing for the state, for the administration, submits that the demarcation notice has been issued in terms of the order passed by this court dated 24th of March 2025, and on receipt of the application from the private respondents. The petitioner has filed the affidavit of service showing that the notice of this case has been sent to the private respondent, but no track report is filed, and he prays for time to file the further affidavit of service showing the showing the service upon the private respondent. Full stop. In view of the above, the case is adjourned. Let the matter appear on 7th July 2025. On the date fixed, 8th of July 2025. On the date fixed, the council appearing for the administration is directed to produce the revenue case, a record of the revenue case on the basis of which the demarcation notice has been issued by the Tehsildar. Next. Yes. Service affected? No.
On Monday and 7.
Not. As per prayer made by counsel for the petitioner, let the matter appear on 7th July. Next. Matter was none appears on behalf of either of the parties. No accommodation is sought for. As the matter was listed on 19th of June 2025, and as per the prayer made by the counsel for the petition, the case is adjourned. For the last 3 days, the matter has been listed, but none appears on behalf of the petitioner. No accommodation is sought. This court finds that the petitioner is not interested to proceed with the instant citizen application. Full stop. Accordingly, CO number 30, CO 35/2025 is dismissed for default. Next.
Then, it's for job, nobody got it. He also got it.
Copy can be given, but.
Not served.
I saw.
You had appeared on the last occasion.
I did.
On the last occasion, you appeared. You both appeared. On the prayer made by the senior advocate appearing for the petitioner, notice is released.
The copy is there.
Give the copy, give the copy.
I will give one copy.
No, Chakri, see, only why your assistant secretary has taken the decision instead of referring the matter to the labor court? How the assistant secretary can pass an order without referring the matter to the labor court after receipt of the failure conciliation report?
They have the part, the 12.5, my lord, the judgment is there.
But see, he has given the reason. Yes, reason.
And this is a case.
If it is that, yes, it cannot be, there is no, but it has been given, and the assistant secretary has given the reason. Kindly come to the. Kindly page 46. Now therefore. We can say 12.5, if there is no reason to send, it's okay. There is no dispute. See. Okay, you go through, come next day. Come when? Tomorrow, day after. As per the prayer made by the counsel for the administration, the case adjourned, let the matter appear tomorrow.
Number 24.
Yes.
You must refer my younger friend starts. And you see two judgment selection. One by Madras High Court Fellowship and one by Calcutta and Admission Bench of the President. Same issue was about making power coupled with interest. In that situation, the court said that it cannot be, upon death of the person concerned, it cannot expand or it cannot be devoted.
Which paragraph?
Paragraph 21, 26 and 28.
21.
21, 26 and 28.
Yes.
And paragraph 21 to 24.
Yes. Yes. That's all. Yes, Mr. Mondo.
Millard, as per the respondent, after going through the pleading, your lordship, it appears the appellant was the plaintiff in a suit for a specific performance filed before the Court of Assistance based on a oral agreement of sale. An oral agreement, this is very crucial, Lordship. The oral agreement,
Oral agreement coupled with the power of attorney,
Lordship. But instead I've gone through in live streaming. So I've gone through, I note down all the points. Lordship, it is very important to note that the oral agreement as alleged by the plaintiff or claimed by the plaintiff executed in the month of May 1988.
Yes.
Lordship. Then 22nd June 1988, claiming that an registered power of attorney was executed. Now, Lordship, before going into the marriage, may I bring to your Lordship kind attention that a contract for sale is not prohibited under law. It is valid. But a contract for sale, oral sale particularly, to be established by adducing the evidence, the person in whose presence it was made. Execution is made, but in whose presence the factum was made. So may I draw your Lordship kind attention, the first point, the execution of the oral agreement is not proved, on the basis of which the plain case is started. Lordship, kindly come.
Yeah, 1:30, come after lunch
Lordship.
at 2:15.
Lordship.
हमारा बोर्ड नहीं है। काम करता है बोर्ड? बोर्ड काम करता है? All the other matter. Paso.
I am opening for this petition in one of the matter and another filed by the.
What? Labor matter? Who is for the other side?
That's a third piece of it.
Reading is completed.
I think last time they have short for time for filing paper, but it's not required.
Adequate number of paper book be prepared by the division forest officer and inspector of both applications and copy be served upon the council for the. Why paper book?
Last time they said that we will file a paper for all stuff. That also I have raised.
They are not filed. Paso. Yes.
Direction to file paper book.
Why paper book is necessary?
Records are there. It is under preparation, my lord. It should be ready in a week.
How much? 1 week.
Weeks, my old papers are there.
And it counsel for the respondents praise for actions on uptime to file paper book. Let paper book be filed within 2 weeks. This is the matter. After serving the copy to the Senate council appearing for the petitioner, placed before the next available judgment bench. Yes. Whether he will be available during circuit. Uh, 14-15 record an order. Let the matter appear on 8th of July. 8th of July. Let us.
In my lord, this concerns the service condition of employee of district judiciary. Mr. Tulsilal, my lord.
He's not here.
I have filed a CAN
For
application, my lord. This extension is being given by the administration continuously. Despite of that, artificial breaks are being made by the respondent number. So Lal is not there. Let me go to the next service. His bike is also going for not aware.
come on the next circuit. As per the prayer made by the council for the respondent, let the matter appear before the next available circuit bench. Next. Items? 18 pass on. अच्छा 18 second of it. Mr. Marul.
Ready, with regard to that application. If I tell you-
Serve the copy.
Yes, I have served the copy.
Okay, pass over. Next.
In 1984, I was doing my main. Very good response.
Which were the other respondents?
Because of this appearing in item number 19, response number 1. So, 20, so we is the one the regular response.
Where are they? Superintending engineer, Koda municipal council. Yes, what is the matter about Mr. Japson?
This is not a case where it can be said that without sanction plan building has been raised. There is a sanction plan obtained by my client's mother. Building has been raised. A adjustment block order filed a repetition. A direction was simply issued by this court in the repetition directing the council to take a decision. But decision during the pendency when the decision was not taken, an inspection was held. In the inspection, it has come that no construction is being raised. I'll show that. And I prayed in interim protection when the repetition was moved for the first instance. Well, see that order once, because it quickly disposed of the repetition. But it's order dated by Justice hearing the location, the first order. 6th February 2024.
Yes.
Want to see that order?
Yes.
My point of argument will not see that order. It's in the interim form, but possibly virtually entire thing has been decided. As regards the inspection report at page 46, as regards the interim order being passed by the council, Lord would see page 46 of the repetition once. There are 3 buildings, the council says there was an inspection held.
Yes.
Lord would see page 46 and this placing this report dated 8 September 2023. Inspection report of the building belongs to K. Krupabai, Nagmani, and Srimati K. Nirna at South Line. The site survey number 3070, measuring area 322 square meters situated at South Line village, recorded in favor of Srimati K. Krupabai, wife of Sampath Rao, out of an area of 150 has been jointly mutated in the name of Nirmala A. Nagmani and V. Vijay Kumari, has joint 50 square meter each has been jointly inspected by the concerned engineer and officials of Port Blair Municipal Council along with the council Mr. Tapan Kumar Das on behalf of the petitioner Alima Bibi. That is Alima Abe on 7/9/2023 and the details are furnished below. Building number 1, madam. There exists a single story RCC building constructed long back belongs to Srimati Krupabai wife of Sampath Rao, wherein she has residing along with her husband, and no construction / extension work is going on at site. On site inspection and inquiry, the party has revealed that the party has obtained the approval from the Kottayam Municipal Board. While reference number so and so dated 23/1/1991, approval number 962, photographs of the structure is placed on the file for reference. Building number 2. There exists a single-story RCC building constructed long back, belongs to Srimati K. Nagamani, daughter of Sampath Rao, wherein she had residing along with her family, and no construction / extension work is going on at site. Building number 3. At page 46 below. There exists a double-storied RCC building belonging to Srimati K. Nirmala, daughter of K. Sampath Rao, and B. Vijay Kumari, wife of B. Janardhan, in which half portion of structure of the building has been occupied by B. Vijay Kumari, wife of Janardhan Rao. Another half portion is belong to K. Nirmala, wife, daughter of K. Sampath Rao. During the inspection, it is found that no construction activities ongoing site.
Yes.
Thereafter, this notice was issued to my clients at page 47. I appeared and I filed my short notes of argument raising all these points. Page 49.
Before the municipal authority.
Council, yes.
Yes.
And finally, by order influence, both at page 51 and 53, none of the points were taken care of.
Yes.
It's mechanical order. Normally, it's been filed in every cases where even the sanction plan is not obtained. The same way it has been. The points which are urged in my written notes on argument at page 49 and 50 was not taken care of. I'll show the plan. It's part of the petition. I have obtained a plan. My mother obtained a plan.
Yes. So what is your prayer?
My prayer is to set at not these two orders. This order needs to be set aside. And if the other side says that Lordship, there is a reasoning assigned, Lordship, I don't find any reasoning. No, reasoning is the heart of every decision-making process. When I raise this point, inspection, their own report says so, that no construction, no extension has been made. There is a plan accorded to my mother at page, at page 35, 36, 37. These are the plans being accorded by the Codified Municipal Council to acknowledge it in the inspection report. As regards the sanction plan being granted.
Yes.
See, the plan was sanctioned in the year 1990.
Correct. But where is the finding the plan which they have relied upon that is not connected with this building? Where is the finding?
Because as per the earlier petition order filed by the adjacent court holder, this honorable court by page number 43 specifically directed. If may not permits, I can read it.
43.
Yes, sir. Then page number 2. Second paragraph, thereafter, an opportunity of hearing shall be given to all parties. In the event it appears that any unauthorized construction has been carried out,
Then necessary steps.
shall be taken.
Correct.
But while at inspection, as Milord has seen at page number 46, not the plan was given to Kripa. He was the original owner of entire chunk of land at the time when the plan was sanctioned.
Correct.
In the year 2015, the property was sold to Nirmala and this Vijay Kumari, and they have purchased. And
Nagmani.
They have purchased. And at the site when inspection was carried out, they found that these persons have made a construction over the
Property.
and they don't have any building plan. As such, an order
So
under
that's why I'm telling, kindly come to your impugn order.
provisional order.
Provisional last, page 51. Page 51. What you held? Whereas Karpo constructed a building after obtaining from so. Nagmani constructed a single-story building and Vijay Kumari constructed a double-story building with the common wall on the area so without obtaining approval of building plan. Correct. When the building was constructed.
But 2015 was the mutation because the original plan was 1991.
Correct.
The name of Kripa.
Correct.
The entire chunk of land that was 3
So you have to take task with regard to the building plan which you are having, which they are relied upon. There is a plinth area and the building which they have relied upon, they are telling that this is the building which is approved by the municipal council sanction plan, and the building which other two buildings which are there, whether they are not, where is your finding? Where is the report on that? That is the stand taken by Mr. Japal.
So for the stack, we do not something because stack acceptance. But the building plan, as they say that the building plan was that the entire property. If you always see the building plan.
Correct. That's, we cannot, neither myself nor you.
This is.
We cannot. It is the expert. That's I'm telling. The building plan is with you. Correct. And building plan having the area. What is the total plinth area? What is the FAR? What is the length, height, whatever it may be? So
What I'm
that,
saying that let them inspect and say that whether the plinth area should be counted in zone of.
that is or not, whether that building plan is violated or that building plan is not connected with this building. Where is that finding?
Next is page 53 is the provisional order. After this order, they issued a provisional order, which is the subject matter.
So I am cautioning it with the direction to take appropriate step by giving an opportunity of hearing a fresh inspection be conducted in terms of the building plan which the petitioner relying upon.
But that means, that building plan, if they are not covered, then.
That's why-
In terms of the municipal regulations.
So conduct the physical verification, inspection, taken into consideration the building plan with the petition relied upon. If this building is not in consonance with the building plan, you take appropriate decision in accordance with law. Yes, Mr. Jabbar? And with regard to the superintending engineer power,
But that's not what I'm giving up.
Giving up.
Because I cannot argue at least this point before my order. Had it been some other time, I could have asked. I did not argue this point before this court now.
There is some delegated by the second.
So like, I did not record that, I'm amending it, my, right? Not-
I am deciding that this court is not decided. So this is all 21, these are 19, 20.
20.
The petitioner has filed the present date application challenging the order passed by the superintending engineer. Number 3, passed by the superintending engineer, Municipal Council, Vijayapuram, South Andaman, by order number 6247, dated 26/12/2023, wherein the petitioner is directed wherein the concerned officer of the Portland Municipal Council are directed to initiate further course of action in respect of the unauthorized construction carried out by the petitioners as per relevant rules and regulations. Counsel for the Mr. K.M.B. Jaipal and advocate appearing for the petitioner submits that the respondent number 3 has passed the impugned order without considering the building plan which was approved by the Port Blair Municipal Council. Port Blair Municipal Council, Dadan Municipal Board being building plan number 962 dated 23rd of January 1991. Mr. Jaipal has relied upon the inspection report dated 8 September 2023, wherein the building inspector has mentioned about the 3 buildings, and as per the said report, it is categorically mentioned that during the inspection, it was found that no construction activity is going on at the site. Mr. Jaipal submits that before the respondent number 3, the petitioners have filed the written notes of argument, raising all the points, but the respondent number 3, without taking into consideration the written argument submitted by the petitioner, has passed the impugned order. Mr. Rakesh Kumar, an advocate appearing for the municipal authorities. Municipal authorities submit that the building plan which the petitioner is relying upon is not the plan is not the plan with respect of the building of the petitioners. He submits that as per the inspection, it was during inquiry, it was found that the buildings were constructed by the petitioners without the building plan, without the sanction of the building plan, and accordingly, the respondent number 3, being the competent authority, has passed the impugned order. Full stop. At the learned counsel for the respective parties peruse the materials on record. This could find that the petitioners are relying upon the building plan being number 962 dated 23rd of January 1991. It's 1991. The authorities are taking the have submitted that the building plan is not in connection with the alleged buildings which have been constructed without the sanction of the building plan. This could, without going into the merit of the matter is of the view. By sitting in the writ jurisdiction, it is not possible for this court to decide whether the buildings have been constructed in terms of the sanctioned building plan as relied by the petitioners. All the buildings constructed by the petitioners are without the sanction of the building plan. Accordingly, the impugned order and full stop. This court also find that the authority, while passing the impugned order, has not considered whether the building plan which the petitioner has relied upon is connected with the said buildings which is situated in the property in question. Accordingly, on the said ground only, this impugned order is set aside and remanded the matter back to the superintending engineer for the municipal council for deciding the matter afresh after taking into consideration of the building plan submitted by the petitioner, and if necessary, the superintending engineer may direct the concerned building officer to cause a fresh inspection over the 3 buildings, and by taking into consideration of the plan which the sanction plan which the petitioner relied upon. After giving an opportunity of hearing to all the concerned parties, the superintending engineer shall pass reasoned order within a period of 8 weeks from the date.
All points.
As this court has not gone into the merit of the matter, accordingly, all the parties are at liberty to raise all the questions before the superintending engineer at the time of hearing of the matter. This was of both 8 weeks. 1920 दो था. Yeah, वो कल second appeal. You will take time, na? So other matter release.
Item number 21. Item number 21. Because here, this deal is opposing similar matter pending before other high court.
Other high court?
Other high court. Last occasion, the matter was heard for 3 days. Thereafter, when my lord Justice Tapabrata was about to pass the order, write that there is an order of the single bench which is challenged before the division bench of the Guwahati High Court, because this is with regard to airport authority of India. So then my lord said it would not be appropriate on my part to pass any order, and therefore my lord, this matter was adjourned. What we are praying, because it's my application, my client is also retired from service. So let it be out of this, my lord, liberty to mention.
It could not be made, I think. As for the parties are pressurizing me to dispose of this matter.
So what has happened to the appeal pending before the Guwahati High Court?
That time.
What is the status?
Okay.
Okay, I am fixing it next week. You take instruction. If it is disposed of and any order is passed, then it can be passed. If it is pending, then I will.
Last occasion, my lord, when we argued, I requested my lord to pass an order or this way or that way, because.
No, but if it is pending, it is not good for the. As per the prayer made by the council for the parties, let the matter appear on 9th of July. As per the prayer made by the petitioner, let the matter appear on 9th of July 2025.
One small, item number 22 and 23. I have to file affidavit in reply. I need 10 days time and 10.
Which for the petition?
I am for only petition. For forest department, you have filed I have to file my
Your reply, how soon?
10 days.
Next week?
Then it's not possible.
That they can file, but only one submission, this matter is pending before Supreme Court also.
That is altogether.
And in similar matters, those matters have been made silent, and because unless and until.
What is the issue?
The issue is, my lord, that some persons were regularized, they encroach forest land. Now, my lord, Godavarman judgment, that is pending, my lord, before Supreme Court. And Supreme Court, we have prepared a list given it.
Empower committee report is there. Central Empower committee report.
Person was granted license. So benefit of that, I am praying at par with that person.
But all other persons are not given.
So, sir, whether all these matters have been placed before the Central Empowerment Committee?
Yes,
Yes.
yes.
It was taken.
Yes, sir.
What decision has been taken by the?
No decision has been- Because it is lying before the Supreme Court.
No.
Supreme Court says unless and until we take the decision, you cannot.
One person was granted license.
Okay.
My clients are out of.
Advocate appearing for the petitioner praised for extension of time to file reply. Let affidavit reply be filed within 10 days. After serving the copy to the London Council for the respondents, list the matter before the next available circuit date, which is by 22 and 23. Yes, call.
What shape?
Yeah. Yes,
Lordship, before going to the merits,
yes.
Lordship, draw your Lordship kind attention the substantial question of 2 and 3, Lordship, page 162 of the paper.
162.
162, Lordship.
Yes.
Second question is, Lordship, whether a specific performance of subject contract would be granted in favor of the appellant. And third is whether the appellate court erred in appreciating the oral evidence of the parties. So these include everything, the appreciation of evidence, readiness, willingness, limitation, everything's come within the ambit. Lordship, just before going into the merit, I am giving some sequence for understanding the nature of the case, Lordship.
Yes.
Since the suit was for a specific performance based on oral contract of sale and subsequently a deed of registered power of attorney. Lordship, kindly consider that oral sale agreement as claimed by the plaintiff is made on May 1988. Then, Lordship, registered power of attorney executed after 1 month, that is 22/6/1988. And thereafter, as per the pleading of the plaintiff, the principal died 2 and 3 months thereafter, after execution of the registered power of attorney. Lordship, after death of the principal and or the vendor, the should property is mutated in the name of the respondent in the year 1993, that is 6/4/1993. And thereafter, this appellant, the plaintiff, applied for necessary papers from the concerned authority for execution of sale deed, that is in the year 1990. And first time, this appellant had been to the Tahsildar, though it is a wrong forum for registration. They made a complaint for registration of sale deed against
Initial 1988.
88.
Then died when he died.
Died after 2 and 3 months thereafter. And this is the first time made complaint to the Tahsildar, that is 3/8/2009.
Okay.
3/8/2009.
Okay.
Thereafter legal notice served.
2009.
2009.
Okay.
And legal notice served 15/6/2013.
Okay.
And suit filed on 22/11/2000.
15/6/2000.
Lordship,
Legal notice 15/6,
15/6/2013.
13.
13.
Okay.
And thereafter suit filed on 22/11/2013.
Yes.
Now, Lordship, I intend to take and already taken the various ground limitation as well as readiness, willingness, as well as non-joinder of necessary parties. And I gone through the entire evidence. The power of attorney as well as the oral sale agreement is not proved. So I'm coming one after one here, Lordship. The execution, Lordship. Lordship, kindly come page 3, the plate of the appellant. Paragraph 3, I am reading, Lordship.
Yes.
That one Sri Nityananda Rai, husband of the defendant, is deceased, had an oral agreement in the month of May 1988, entered into a contract with plaintiff for sale of 680 square meters of land bearing survey number so-and-so, Rampur village, Rangat Tahsil, as the shoot property for the sake of private, more explicitly described in the schedule shoot, a total sale consideration of 82,000, Lordship. And on the same day, Sri Nityananda Rai received rupees 82. This is very important, Lordship. And from the plaintiff, being the full and final sale consideration amount and handover the physical possession of the said piece of land to the plaintiff, authorizing him to make any housing structure or develop it any way. Lordship, then paragraph 5, Lordship. In pursuant to the said agreement, plaintiff has occupied the property measuring itna, subsequently by spending an amount of rupees itna, constructed double-storied semi-RCC house over the site by modifying the side land and also planted plants. Now, Lordship, paragraph 3, it appears that an oral contact is made, but there is no mention the attesting witness. There is no mention in the entire pleading with regard to the where and in whose presence and the execution is made or the oral sale is made. There is nothing mentioned in the entire pleading.
Yes.
And received rupees 82,000 on the date of execution and handed over the physical possession. Now, Lordship, come the power of attorney, Lordship. That is appearing, Lordship, page 62, Lordship.
Yes.
62, Lordship. 63, paragraph 10. Paragraph 10, Lordship. Lordship, may I read?
Yes.
To sell out or dispose of the said part of land or its parts thereof to any person at any cost or as a free gift, as our said attorney may think proper and found it fit to his own discretion, as we have already received rupees sale consideration to the tune of rupees 82,000, on receipt of which we do hereby jointly and severally acknowledge in cash in full from our said attorney, and Abhilash Chandra Rai duly executed and presented him this deed and physical possession over the said property being handed over to him, being taken.
Token the respecter, yes.
There is a contradiction. As per the power of attorney, on the day, this is, I'll read only the particular paragraph, but from the entire conjunction, it's appear that he received self-consideration only on the date of execution of power of attorney and handed over the physical. But for the plain paragraph 3, he said that sale agreement is made on May 1988, and on the same day he received 82,000 self-consideration and handed over the physical possession. This is the contradiction.
What is the date of the power of attorney?
Power of attorney, Lordship, it is 22/6/1988.
Yes.
Just after 1 month.
Correct.
Now, Lordship, I'm coming to the execution, the evidence of PW1, Lordship.
But paragraph 10, if you go to the paragraph 10,
Lordship.
in the middle, as we have already received a consideration to the sum of rupees 82,000 and receipt of which we do hereby jointly and severally acknowledge in cash in full form our attorney Abhilas duly executed and presented him this deed and physical person over the property being handed over to be as a token received with the consideration as aforesaid. So already paid.
Already. Lordship, I could understand that if there is mention of factum of oral cell in the power of attorney, there is nothing mentioned.
Oh.
There is nothing mentioned in the entire power of attorney with regard to the factum of oral cell.
Yes. Yes.
Now, Lordship, then come to page 82.
82.
82, Lordship.
Yes.
82. This is the first time
They have complained to the Tahsildar.
Tahsildar.
Yes.
Lordship, I gone through the entire aberment. There is nothing mentioned with regard to oral cell. Only they are mentioned with regard to registered power of attorney on the basis of which he applied for registration of sale deed before the Tahsildar.
Okay.
There is missing with regard to the factor. Now, Lordship, kindly come the PW1, Lordship. That is page appearing in page 34, Lordship.
If suppose oral agreement not pleaded or pleaded not put, whatever it may be, as taken. But the power of attorney is a registered document, admittedly 82,000 rupees taken and possession give.
Lordship.
What would be effect?
Lordship, I'm coming to that. Lordship, know that mere registration of a document does
No,
not.
I am not harping upon the registration document.
Lordship.
I am only informing it is the registered document.
Registered document.
And power of attorney says whatever the power is there, with, but the amount paid and possession given. And what would be effect of that?
Lordship, that's I denied. First of all, Lordship, kindly come to my written statement. Written statement, paragraph 16, Lordship.
Paragraph 16.
Page 16, Lordship.
Yes.
Page 17, Lordship, paragraph 80.
Okay.
It is submitted that, Lordship, with reference to para 12 and 13.
Yes.
It made therein that it is submitted that it is incorrect statement of the plaintiff that the property can be transferred in his name. It is further submitted that the portion of transfer of suit property in favor of the plaintiff does not have, and no agreement either orally or in writing or any power of attorney on consideration as ever executed or any consideration money was received by the husband of the defendant. The plaintiff was malafide intention to grab the property. So I vehemently denied, Lordship. Thereafter, paragraph 9 also.
Yes.
Page 19, paragraph 19 also. Lordship knows that registration of a document is a mere notice to the public that a document is executed. Not more than that, Lordship. It is a mere notice to the whole world.
Correct. No problem.
Lordship. Now, unless the document, when I vehemently denied the content of the document, it is the duty of the appellant to prove the document by calling witnesses.
Yes.
But no witnesses was brought before the either the trial court, or there is no petition for such prayer before the first appellate court.
But the power of attorney was exhibited
Power of attorney is exhibited.
with objection or without objection?
Lordship, I denied since it is denied.
No, you denied, but at the time of objection, you raise objection or without objection. If there is no objection, no need to further prove.
Yes.
Whether it is objection, with objection, it is exhibited or without objection.
It is appearing, Lordship, page
Page 61, but it is
this is not mentioned, Lordship.
it is not mentioned.
without objection, because even in the examination sheet, it is not there.
Exhibit 1
No, it's not there.
without objection. Yes, next.
Now, Lordship, page 35. I'm coming, I'm going through Lordship, whether
Yes.
objection is made or not.
No problem.
I'm going.
Page 30.
Page 35, Lordship.
Yes.
It is from the bottom, fifth paragraph, Lordship. The oral agreement between myself and Nintendo Rai took place in the month of May 1988 at the tea shop of Satish Das
Yes.
in Rangat Bazaar.
Yes.
Probably it was during the evening.
Yes.
In the said tea stall, I had several customers, but now I cannot recall their names.
Yes.
Now, Lordship, this is the first time the name of Satish Das come, but Satish Das was not examined.
But it is in your cross examination, sir.
Lordship, even though it is admitted that it was made in the presence of
Satish,
Satish.
one of the person.
one of the person.
Correct.
Satish Das was not examined
Yes.
because he is the main person. He knows the veracity of the
Yes.
execution.
Yes. Then.
Then page 36, Lordship. Exhibit 1, that is the power of attorney, Lordship, was prepared by one Punchi
Parinchu.
Renchu, petitioner writer since deceased, but not under my dictation. He had prepared the exhibit 1 upon request of myself and Nityandu Rai, but this person was not also examined. The petition, the writer.
Kuchupurinchi. Yes. Yes, next.
I have documented proof that I have objection, but Lordship, then page 36 from last two paragraphs, bottom. Not a fact that I disclosed Sukhada the existence of exhibit 1 in the year 2009 when she asked me to vacate the shootland.
Where from your reading? Not a fact.
From the bottom, second paragraph, Lordship.
Not a fact. Disclose Sugudha the existence of exhibit 1 in 2009 when she asked me to vacate the land. Yes.
Not a fact I did not request each and every principal or legal here that I was not mutated in favor of Sukhada and sufficient in a fact that it was in principle. I had time to raise the document with me were obtained by me as the principal had agreed to. Yes, this is also page 37, Lordship.
Yes.
1, 2, 3, 4, 5, 6, 7 number paragraph, Lordship. Not a fact that document exhibited by me were obtained by me as the principal had agreed to sell the land to some other person, for that I had pre-planned to grab the shootland ever since my entry in the land. Not a fact all other exhibitor manufactured by me for the purpose of this shoot. Not a fact the defendant is the seller the provision of will.
Yes.
So this is the denial.
Correct.
Not a fact the all other exhibitor manufactured by me. Now, Lordship, as per the evidence of the PW1, he disclosed that one Satish Das, he knows the factum of cell and in whose tea stall.
Yes, as per your submission, Satish Das was not examined. As per the case of the plaintiff, the oral agreement in presence of the Satish Das.
Satish.
And
Now-
with regard to the power of attorney prepared by or drafted by Kunchi Purinchi, but he has not
Was
been
not examined. Now, Lordship, PW2. The one, Manoranjan Haldar,
Yes.
was brought by the plaintiff appellant,
Yes.
whose name is not mentioned in the
Did.
or even in the plate. So he is not the signatory of the power of attorney.
Yes.
So anyway, the learned advocate tried to discard his evidence, and there is some discrepancy. But from it appears that he is not the attesting witness.
Okay.
And if he was the attesting witness, his name must appear in the registered power of attorney. But at least
but in the cross-examination, can we come to page 44, third paragraph? It is your cross-examination. There was no written contract between Nityanand Roy and the plaintiff, but there was an oral agreement.
Orally.
No. It is in cross-examination. What is your answer to this?
Lordship, this is the oral agreement, but the content of the oral agreement is not come in the evidence. There is plaintiff also claiming there is a oral agreement. This person is also said in the cross-examination there is oral. But the content of the oral agreement, there is payment of money, that nothing has come in evidence.
Okay.
Lordship knows that the contract for sale, particularly in oral agreement, the execution is not the sole basis of proof. Whether money has been paid or not, this is the circumstantial evidence. Whether any receipt is not, whether any money receipt was executed or not, that is the collateral and circumstantial evidence. And by producing that, the oral evidence can be. Lordship, nowhere I denied in my written statement that no money was received by me. But even the witness did not prove, the witness brought by the plaintiff did not prove that there is payment of rupees 82,000. It is mentioned in the registered power of attorney, but registered power of attorney is denied, but it is not proved. The content is not proved. Lordship knows that mere exhibit of a registered document not is if facts of prove the contents. When I denied in my written statement.
Correct.
Now, Lordship, even the DW Lordship, DW also in his evidence.
But in the page 44, come to third last paragraph. Not the fact that only 200 square meter land was agreed to be sold to the plaintiff by Nityanand. To the plaintiff by Nityanand due to his cordial relationship with the plaintiff, or that the trees and plants. So why this suggestion?
Even
Why this suggestion?
Sorry, in case of but even though that
Okay, come tomorrow. You have some meeting.
Not.